So remember, at the beginning of my talk, I told you that we need a medical expert to confirm that we have a valid basis for a case. And I said there was only one instance in which we don't need an expert. What instance would that be? And it's a phrase in law, it's a three-word Latin phrase that we all know from law school.
Res ipsa loquitur.
Thank you. Excellent. That thing speaks for itself. Correct. That is the only time where we don't need an expert. Now you might be thinking, how does res ipsa loquitur apply in a medical malpractice case? I'll tell you how. Let's say a patient goes in for hand surgery, and they come out of surgery with their hand fixed, but they have a third-degree burn on their shoulder. And they're wondering, how the hell did I get a burn on my shoulder? I went in for hand surgery. Now the patient is told, listen, during the course of surgery, something happened, the drape caught fire, and you suffered this burn. And don't laugh, it does happen. It happens from time to time. So, it turns out that during the course of the hand surgery, an instrument known as a cautery instrument designed to cut off bleeding vessels, to burn bleeding vessels, was used and inadvertently touched the drape, causing it to go up in flames. The nurses and the doctors didn't recognize it, and by the time they did and they smell the smoke and see the flames, because there's oxygen in use, so it's going to feed the flames, this guy had already suffered a third-degree burn. In that instance, it's obvious to everybody what happened. You don't need to have a medical expert come in and explain that if you're going for hand surgery, you shouldn't come out with a burn to your shoulder, right? You don't, it's just common sense, common knowledge. But you will find that the best trial attorneys in New York still will go ahead and hire a medical expert to testify. Now why? Why would they need to go through the expense of doing that? I'll tell you why. Because we want to be able to show to the jury what was done incorrectly. We want to show what the proper procedures would have been to avoid this type of injury. And it gives them additional information to help them make a decision about how careless they were in causing this harm and injury. So typically the defense never turns around and says, yeah, okay, we agree, we did something wrong, we screwed up. But here's something else you need to know. In order to take advantage of this res ipsa loquitur doctrine, we have to be able to show, number one, the patient was under anesthesia. The patient was not in control of the events that were going on, that the hospital staff were. We have to be able to show that the patient did not cause or contribute to her own injuries. If she's under anesthesia, she's not contributing to anything. And that the only people who had control of the scenario, of the situation, was the hospital staff. Only in that instance can we use that doctrine of res ipsa loquitur and not have a medical expert come in to testify. Okay?